Well, we continue our conversation on the suspension of Chief Justice Gertrude Torkornoo, and Joy News checks reveals some members of the Ghana Bar Association want the leadership to rewrite or to write to the president asking for a revocation of the suspension of the CJ. There are so many dynamics because apparently there are claims that some things that have been said are not reflective of the whole body. Others are saying this is the path that must be charted. Well, our guests join us this morning. They are all lawyers and will be getting their take. Christian Mam Hesse is a lawyer. He joins the conversation. We also have Andrews Ejapa Mercer. He's a lawyer and former legislator for Second D, also a former minister for tourism, former deputy minister, I should say, and a former deputy minister for energy as well. Both of them join the conversation for starters. Gentlemen, a very good morning to you.
Morning.
Honorable Mercer, is that you?
Yes, Mercer here.
All right. Can I hear from Mr. Hesse? Mr. Hesse, can you hear me? If you can, please unmute. All right. Let's start with Mr. Mercer on this beat. So Article 146 has been triggered. The processes have continued. But just give us your overarching view of happenings up to this point before we get into the substantive matter. Constitutionally, I mean. Mr. Mercer?
Yeah. Well, let me say good morning to your cherished viewers. Those who are watching us on social media platforms. I guess my views have been made, quite public. I initially, in spite of all the commentary that taking place during the election, I was of the view that if a process of this nature has been triggered, it's important for us to allow the processes to evolve. Okay, so that we can get to the bottom of it with respect to substantive allegations that have been made, whether indeed they can be proven or otherwise.
Right.
But subsequently, the comments from some political actors, especially National Communications Director of the NDC and some power out of your stations.
Are you speaking of Sami Jemfi? Are you speaking of Sami Jemfi? Okay. What did he say?
And then immediately thereafter, I saw a post by Honorable former Deputy Attorney General Asuma Baba Power. Because at all times, material, I had not seen the petition. I'm sure that many of us haven't seen it. And so sometime last week, Tuesday or Wednesday, when it became public.
Right.
Having read the petition, the responses that the Chief Justice offered to the President and the Council of State, I do not think that they, in good conscience, with all due respect to them, could arrive at the conclusion that they did, that there was a prima facie issue that the Chief Justice had to then be called upon to advocate.
We are losing you a bit. The connection seems to be a bit. Are you on the move?
Yes, I am. I just dropped off my kids at school, so I'm driving. Okay.
Could you do us the favor? We want you alive. Could you just park for a bit?
Yes, sure.
Yes.
All right, I'm looking for a convenient place. Exactly that.
Okay. All right. So while you do that, let's also bring in lawyer Hesse, and then we'll continue the conversation respectfully. So, lawyer Hesse, can you hear us now?
I can hear you.
All right. You'd have to speak up a bit, sweetie.
Yes,
I can hear you.
Right. Thank you for joining us. Feel free to give us your initial comments, but there's a new angle to this whole discussion on the suspension of the Chief Justice. The Ghana Bar Association have weighed in on the conversation. I want to know what you make of that before we get incisive with the details.
Yes, thanks for having me, and good morning to our viewers or listeners alike. I believe it is a call more precisely on morality rather than duty of the law. The reason I say call on morality is it is an appeal to the president, and even though I am a lawyer, I would not say I am speaking on behalf of the bar as a PR for the bar, but by way of education and of all that is panning out. I see it as that because if you look at Article 146, there's nothing untoward that the president has done, or there is no breach of any of the provisions as of now. But in looking at the bigger picture, preferably the bar is of the opinion that putting in a warrant of suspension of the CJ it's premature, and more precisely, it should be the exercise of an option that should have come forth as a result of a very supervening offense, a very serious offense that needs not to be hidden in the confines of just a petition, but where such stated misbehavior is so known. From my deduction as well, it feels that it is lowering the threshold of the removal of a CJ, especially where we don't have established procedures the lame procedures as provided in Article 146, and the learned retired jurist in this case of Frank Ajetum elucidated and indicated that it is very important for the Constitutional Review Committee, or better still, through legislation by Parliament, to have an established procedures in dealing with it. So that if you are looking at Article 14610, where the CJ has been suspended through the warrant, just as I said, it is the belief that the threshold is watered down, and as purposive interpreters of the Constitution, one would say, is this the reason the framers of the Constitution put behind it? And we call it the objective test. And in running the objective test with the subjective test, so that the context and test of the Constitution is brought alive, the provisions will such a removal mean what indeed the framers of the Constitution envisaged? The question is one that only a court of competent jurisdiction could answer. And while that vacuum remains, the GBA, in my respective knowledge, could only admonish on the president to rescind that decision and allow for other processes invoked to carry out with what we are seeing.
Right. I get that point about it's just an appeal, but I do want to understand, help me reconcile this. I hear talk about it's never been done before. In fact, some people, Professor Kukwa Asare, for example, is criticizing the GBA that they finally found their voice. I want to understand how, first, there's a statement saying that we should respect the rule of law. In fact, I just want to read a quote from here. It says, while the GBA recognizes the constitutional prescriptions for the removal of the Chief Justice, and mindful of the fact that presently the entire matter is subjudice, It is the hope and belief of the GBA that the actors involved will have the time-tested tenets of the rule of law as their guiding principles. And then, less than a week later, we are hearing that some members of the GBA are unhappy, displeased with this call, this statement, and they're asking that they should revoke the suspension of the GBA. How do you reconcile all these things that the GBA has become, is at the center of?
I mean, for me, the Bar Association of any country should always stand in the forefront of promoting and educating the masses as far as the legal framework is concerned, because we live in a rule-based order. The GBA should be critiquing and be putting papers of intelligentsia out as and when need be. In this situation, the milieu as we find ourselves in has been one of talkative, where commentaries are being run left, right, center. Commentaries are being run left, right, center.
We are trying to, the connection is bad. So, Ben, perhaps we can go to Mesa and then we can reconnect with Mr. Malam.
Hey, Japa Mesa, have you been able to park now?
Yes, I did for a long while.
Oh, our apologies.
Yeah.
We want to be sure you are safe, so please bear with us. We want to be sure you are safe as well. So you were giving your view, initial thoughts on the matter, and then we can get into the purported, wading of the GBA into the fray.
All right, so in brief, all I will say is that in view of all the matters that have come to our attention, that have come into the public domain, one cannot but draw a conclusion to the effect that this was premeditated, orchestrated right from the very beginning to remove the Chief Justice. That's the object of what the NDC government of Mr. Mahama is doing.
I see. Going back to that question of the threshold, the minimum threshold that must be met, it hasn't got to the point where we must look at Article 146 in the Constitution in looking at everything else when it comes to reviewing the 1992 Constitution?
I suppose that we've gotten to that point. Indeed, and in fact, it's not become an issue because nobody has attempted under the Fourth Republican dispensation to remove the Chief Justice.
But there have been petitions.
Say it again?
There have been many petitions against, a number of them.
That the safeguards in the Constitution itself, if this present president and the Council of State were minded to apply it, wouldn't get to this point. Because unlike in the situation of other constitutional bodies or heads of other constitutional bodies, where the president acts as, if you like, a conveyor belt, in this case, for the removal of the Chief Justice, the president and the Council of State plays an active role in the process. And so that active role in itself is intended to serve as a seed where they make a determination at that point whether there's any basis for a full-blown investigation. And I'm saying that if the president and the Council of State were minded to do what it is the Constitution enjoined them to do, we would not get to this point. And so, yes, there may have been petitions in the past, but previous presidents have acted in consonance with the law and have provided a requisite threshold to ensure that we do not get to this point where the Chief Justice is almost on the verge of being.
Well, just to interject, the threshold, I mean, there's no clarity there as far as the Constitution is concerned, or concerned. But if we look at it this way, if I may, Georgina Wood, there were petitions, at least one petition against Sophia Kufu. There was a petition. Justice Enin Yeboah, there was a petition. In fact, when it comes to Gertrude Tokono, there was a petition under Akufo-Addo. It apparently did not meet the prima facie requirements, and now there are more petitions against her, 5 per the last count. If you add the last one, which did not meet, that would be 6 against her. The president, per the Constitution, is only a fan belt, is he not?
Not at all. When it comes to the Chief Justice, the president is not. The president ought to act in consonance with the Council of State to make that determination.
It says that he's supposed to get...
Clear distinction. So the references to all the previous petitions against previous chief justices that you refer to, the President and the Council of State provided the requisite checks to ensure that this serious matter of removing the chief justice was dealt at that point to establish whether indeed there was a need to proceed to the second step that Mr. Mahama has proceeded to. And they all came to the conclusion that based on the responses that the previous chief justices had provided, there was no basis for this inquisitorial process to commence. That's the point that I'm making.
All right. So I always like to go back to the Constitution just for the sake of clarity. It says if the president receives a petition for the removal of a justice of a superior court other than the chief justice or for the removal of the chairman, he shall refer the petition to the chief justice, who shall determine whether there is a prima facie case. However, where the chief justice, I want to get to the relevant point. When the petition, that is 1466, where the petition is for the removal of the chief justice, the president shall, acting in consultation with the Council of State, appoint. Let me finish. The president shall, acting in consultation with the Council of State, appoint a committee. That is where they are coming together to appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons, like we've seen that list now, who are not members of the Council of State, nor members of Parliament, nor others. And then even in terms of the Council of State, it says where the Chief Justice decides that there is a prima facie case. That's on the other end, so not referring to the Chief Justice. Where exactly has the president erred in this whole bit? Where has he erred?
I'm saying to you that the president, in acting in consultation with the Council of State, wants to establish a prima facie. Okay? That is not a passive role. It's an active role. And if a prima facie is established, then he proceeds to do the setting up of the committee. I'm saying that, hold on, I'm saying that is distinct, separate from the process where the president, on receipt of a petition for other justices of the Superior Court, forward saying to the Chief Justice, for the Chief Justice to make a prima facie decision.
Right.
The president does not play any role when it comes to the determination of justices of the Superior Court. But when it comes to the justice of the Chief Justice, the president plays an active role together with the Council of State.
Clarify for me what this active role is. As far as my reading is concerned, it's the Council of State that determines whether there's a prima facie case. Does the president in any way participate in this process in determining whether there's a prima facie case? Does he?
But what provision are you reading?
I mean, I just read 1466. And I'm saying that in respect of the matter being conveyed to the Council of State for some determination, I'm asking you, is there any point where the president himself or herself, in this case himself, participates in the determination of whether there's a prima facie case or not?
But I'm saying to you that the president, in consultation with the Council of State, is active. It's not passive.
So you're saying that the president is...
The president, in consultation with the Council of State, and I've said to you that when it comes to the Chief Justice, against him, then made provision for the prima facie to be established, because in 1466, when it comes to the Chief Justice, unlike other Superior Court justices, there is no requirement for establishment of a prima facie case. But the Supreme Court had expanded this provision to say that it is unfair when it comes to the Chief Justice not to have a prima facie determination. And so that determination, I'm saying, is done by the president in consultation with the Council of State. That's the point that I'm making.
Are you suggesting, and I'll go back to Sweetie shortly, 2 things. Are you suggesting that in the previous petition brought by Professor Kweku Asare, for example, former President Akufo-Addo had an opinion on the matter which he exercised? And
but you saw the letter that the president issued.
What?
You saw the president's statement on the Kweku Asare petition against the Chief Justice.
I did. I'm asking you a question, though. Are you suggesting that the president's personal opinion was involved in that?
What personal opinion? Personal
opinion on the matter. You say the president works in conjunction with the Council of State.
But how do you expect them to issue an opinion in public or what?
I don't think you're getting the thrust of my question. Well, I am saying, is there any point where the president's opinion is factored into the determination of a prima facie case, apart from with the Council of State?
But if the two are working in consultation with, or the president is working in consultation with the Chief Justice, his view is irrelevant.
I see.
That's what makes this particular instance nothing but political.
Okay. So
because, look, people have made references to 296 and the exercise of discretionary power. 296 is clear on how that power is exercised.
It is? Because when I read 296, you go ahead. Go ahead. Go ahead.
That the exercise of discretionary power shall not be arbitrary, capricious, or biased, whether by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. Now, the point that we're making is that the president is exercising the discretion to even suspend the Chief Justice, did not follow this constitutional injunction.
How can you prove that? 296 is pretty nebulous on that matter. What if we say there's no? Okay, so let me explain myself. If 146 were to be Andrew Sejapa Mesa, let me explain myself and then you can respond. If 146 does not meet the certain threshold that you speak of, where we should have a threshold for even bringing up such cases, how can you then tell me that 296 is clear enough when it talks about discretionary power not being biased and all that? By whose standard? What standard is that?
You are not listening, whether deliberate or otherwise.
Well, tell me again then.
Please, I'm saying to you that the 146 provision is a two-step provision. It's a two-step process. First step introduced by Ajetu, which says that before a committee is established,
right,
the president, in consultation with the Council of State, must first establish a prima facie case. I'm saying to you that it was as a result of this that the Chief Justice requested for a copy of the petition and subsequently submitted her responses to the president, who then forwarded it to the Council of State. I'm saying that process itself, if it was not actuated by political consideration, would not have led to the second step of the committee setting. That's the point that I'm making. Because that process itself is intended to ensure that frivolous applications or petitions do not cross the prima facie threshold into the setting up of the committee. That is how the Constitution has designed that process to be. Now, for it to be referred to the committee and the president proceeding to suspend the Chief Justice, I'm saying that it was actuated by nothing other than politics. The president was biased. His previous comment on the removal of the Chief Justice is obvious, is in public domain. His party chairman, his general deputy general secretary have all made comments that suggest that the NDC intends to remove the Chief Justice, and that's exactly what they are carrying through. So the comment of the statement by the Ghana Bar Association becomes relevant, that you may be acting according to the letter of 146, but bear in mind that the constitutional framework or the framework of our Constitution intended that when you are interpreting or applying the Constitution, you don't look at only the letter, but also the spirit of the Constitution.
Mr. Andre Japa Mesa, I want to go back to Mr. Hersey in a bit, but help me understand where the intersection is between what the GBA leadership said a week ago and the comments coming in from some members who are saying they are going to call on the president to revoke the suspension of the Chief Justice.
And there's not some members who are calling on, who are making comments.
Is it the association, the Ghana Bar Association proper?
there was a mid-year conference of the Ghana Bar held on Saturday.
Yes.
Where the statement that the Ghana Bar Association had issued earlier came up for discussion. And the membership resolved that it wasn't enough. The president had taken a step that put the entire judiciary at risk, in danger. If we do not act decisively, we're going to have a country that had the judiciary that was working at the whims and caprices of political actors. And so that resolution has been passed, calling on the president to abide by the Constitution to the extent that his action in suspending the Chief Justice is clearly inconsistent with the provisions of Article 296, to go ahead and revoke that suspension in accordance with Article 146(11).
My apologies for coming in here. Just clarity. Did you just say that the members resolved to do this?
Yeah, there was a resolution that I wasn't there. But I'm told that the Bar Association passed a resolution.
I see. Who told you this? I mean, can you share?
It's all about social media.
Okay, that's precisely why. I've seen it, and I've seen something shared by some lawyer in respect of this. That's my curiosity, because just this morning, for further clarity, I just interacted with our court correspondent, and there was a further interaction with the PRO of the Ghana Bar Association. I'm talking about Xavier Kuje Esquire, who is a PRO, and he says there was no such resolution. So that's why I'm questioning what exactly. Have you seen this resolution?
Hold on. Your producer who called me. I told your producer I wasn't at the event.
Right.
And he confirmed that he has also spoken to lawyers who were present, who confirmed that the resolution was actually passed.
Okay. So, and granted, you were not there. I can't hold you to what happened there. You were told.
I was taking you tour on with Dr. Bamia in Western Region.
Right. My producer says in engaging you, though, he didn't say that the resolution had been passed. But let's look at it from this way. If the PRO of the Ghana, okay, let's go past that. Let's go past that. Right. Let's go past that.
Now I want to know
if the PRO of the GBA.
Clarify for me if Eko is the one who told you that.
Yes, he is telling me that.
Okay, all right. Then I'm not going to proceed with this conversation. Okay.
Right. Okay. So that is Ejapa Mesa, Andres Ejapa Mesa. That's an interesting tilt on the conversation, because he insists that something was said. And of course, my producer also says he never said that to him. But that's an interesting bit, because there has been this resolution on social media. You may have read it. And claiming that there was some resolution by members of the Ghana Bar Association at that conference that, these actions should be truncated. There should be a suspension of the Chief Justice. But in our interaction, as confirmed by our court correspondent this morning, I just don't want to put his name out there. In fact, I've been engaging him. We did that this very morning. And Xavier Kuje, who is PRO of the Ghana Bar Association, says there was no such resolution. So then that leaves all of this in some limbo. But what's interesting, sweetie, is that you then have a reaction of someone who has actually put in a petition before against suspended Chief Justice Tokonu. My apologies, suspended Chief Justice Tokonu. That is Professor Kweku Asare, who has quite a number of things to say. He says that less than a week after calling for the rule of law to prevail, the GBA has reversed course, now urging the president to revoke the suspension of the Chief Justice. And he's basing his point on that same social media interaction. He says, it's good the GBA has finally found its voice. He was writing on X. But then he enumerates a number of matters that he feels still hold the feet of the Chief Justice to the fire of accountability. It's interesting, isn't it? Have they resolved? Have they not resolved? What is the situation? If the PRO of the GBA tells me there's no such resolution, of course, I'll take it.
Yeah, because that's the PRO for the bar, which is why I started by asking him comments from members of the GBA. But we still have Christian Malamhesi with us. You've been following the conversation to this point, and I know you wanted to also elucidate the significance of GBA statements and all, but we lost the connection. So let's get back to that.
Yes,
Mr.
so
Ese,
it's Hesse. What I mean, whether GBA had run a resolution or not, like I said, the GBA as an intelligentsia group definitely must make pronouncements periodically concerning the state of rule of law in the country. And it is not new. It's not new to Ghana. It is the order of the day in other countries where the rule of law is thriving. The GBA must always be seen as leading the way by putting up either academic papers out or legal communique out on matters of public interest, so to weigh the direction as it may be on such matters. Yes. So the GBA should always be seen as a driving force when it comes to legal matters in any country, in Ghana, and the Bar Association in any country.
Now is the leadership of the GBA, and I say leadership because the first statement last week, I think was on the 24th of April, signed by the president of the Ghana Bar Association and I think the secretary, said that they hope that we will respect the rule of law. And that's from the leadership. And now we're hearing that some members, not the GBA, passing the resolution to call on the president to revoke the suspension of the Chief Justice. What does it say about the GBA's position on this? It looks divided, does it not?
Oh, I mean, it is only a dissenting voice. I mean, however unofficial it is, it is only a dissenting voice who can be rooted to the bar. Because, just say, example, you have the Engineers Association. There would be an official communication from the leadership of the engineers, but definitely you would have a portion or, a proportion of the members who also have a certain belief. And by that belief, they could sign up under a letter and have that circulated. It all eulogizes the beautiful democracy that we have, that it's a rule-based order. However unofficial it is, they are also communicating to the president. The president, as the Constitution requires, exercise his discretion. Because if you look at Article 146, it uses 146.10, which deals with the drawing of the warrant of suspension. It uses the permissive word as may, so it is not shall. So the president exercised that discretion. And that's why in my plenary remarks, I indicated that would it be that every petition against such office would come with the exercise of suspension? It is indeed an area that it requires serious legislation or established procedures of law, so to deal with that area of ambiguity. The whole, especially the second limb of Article 146 is plunged in ambiguity, and it's mostly left to what the bench called filling the gap, and that's what the Frank Chum case did, where Dr. Dateban gave the lead opinion and dealt with serious issues, tackling the omission of prima facie, who determines prima facie, and subsequently urged that there should be a procedure established in dealing with this particular matter. Further urged the Council of State to get eminent experts to assist them carry out this mandate and all of that. So it is an area of law that is gray, that does not have proper legal protocols to govern or to navigate the waters, and that is how come we find ourselves in all of this.
So be that as it may, in the words of the GBA, they said this is subjudice. I'm not a lawyer, but I understand this means that it's under judicial consideration, which in most cases means that it should be prohibited from public discussion. So should members of the GBA be running commentary on what the president should and should not do on this matter, after the GBA has issued a statement and clearly stating that this matter is subjudice? That's the point I'm trying to get to.
Yeah, I mean, subjudice, yeah, basically, like you said, I mean, when we say a court is subjudice, it basically means that the court has taken charge over the matter. The proceedings are ongoing, so yes, general education can be hard on it, but determining the outcome, digesting steps to be taken by the judge and all of that should be withheld, and that's it, because you risk the issue of contempt and all of that. But be it as it may, this is more precise judicial body that is determining this. But like I said, the uncertainty of forces is what has generated the public interest and all of this.
Right.
And we only pray that the Rules Committee would deal with this, as Dr. Dateban also called on them in the Frank Ajechum case,
right,
at the Supreme Court some time ago.
Just a quick one, or two, I should say. If you look at 146.11, that is where it says the president may at any time revoke a suspension under this article. So a revocation of the suspension when imposed. But if you go to 10B, it says where a petition has been referred to a committee under this article, that is the Council of State or maybe the committee after post the fact. B says, in the case of any other justice of a superior court or of a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. I do not see, I just want clarity on where it says may when it comes to the suspension of the Chief Justice. Can you give me clarity on that?
So if you read the provision on the suspension of the Chief Justice, it does not, it is not mandatory. It is not mandatory.
But it can be applied.
It's only permissive. It's not mandatory.
It can be applied.
Can you hear me, please?
Yes, we can. We're hearing you.
It is not mandatory.
Which means it can be applied. Discretion, based on discretion.
The circumstances should warrant that. The nature of the offense should warrant that. And so that leaves it in the hands of the president to do that. That is why Article 296 comes in with the issue of discretionary power. And that such discretionary power should not be laced with any idiosyncrasy, should be fair, in the exercise and all of that. You see, the Constitution is not read literally. We have moved away. Ghana has moved away from literal interpretation. We now do what we call purposive interpretation. If you look at Tufo and Attorney General, Salah and AG, and many of the constitutional cases.
I think you're trying to land somewhere. Let me ask you this.
Justice Adadi,
Mr. Hesse,
and indicated that the spirit and letter of the Constitution must always be considered.
Can you hear me, Mr. Hesse?
Interpreting the Constitution, because the Constitution is a living organism.
Okay, it doesn't. I don't know whether.
Political document.
Can you hear me, Mr. Hesse?
Yes. Can you hear me, please?
Okay. When you speak, it appears you don't hear us when we interject. I just wanted to find out from you, based on what you, as a lawyer, have seen, though the PRO of the GBA says there's no such resolution, do you think the bar was met for a prima facie case to be established? You seem to lean in a certain way. I just want to find out categorically from you. Do you think that threshold was met? And if not, why?
With issue of prima facie, however the degree of it may be, it is a constitutional mandate of the Council of State to determine. It will not be my respective opinion to determine that because I don't have the facts for me. So once the respondent has a matter to respond to, the determining or the determining umpire who decide to say that there is a matter to respond to, and by that there is a prima facie. Prima facie basically is that yes, there is a matter to determine. There are tribal issues. There is a matter to be determined on the face of the petition. So, however that umpire determines fit, that is that discretionary authority vested in it constitutionally to determine that. And if in the wisdom of that collective, they have that judicial consideration or opinion that this is the way to go, nobody can challenge that constitutional decision that they have taken, unless it is one that is unconstitutional. Then yes, you can have redress in court as that which they have done. Let me fall within the annals of the law.
Let me state categorically, my producer insists that he never communicated to Andrew Sejapa Mercer to say that the GBA had a resolution on that matter. He wants it to be forcefully, put through. And that was the allegation made by Andrew Sejapa Mercer and the grounds on which he exited the conversation this morning. I'm not, trying to impugn him, but I'm also just speaking on behalf of my producer who wants this to be clarified. It's unfortunate that Andrew Sejapa Mercer did not stay with us for the rest of the conversation. Just to end with you, and Sweetie will conclude the conversation, is it odd that constitutional processes have been triggered and the GBA head, Madam Gatti, also makes mention of certain changes that ought to be brought to bear? We know that the law can't be retrospective, and once it is what it is what applies. So in terms of an in-camera option, for example, for it to be made public, none of that can apply now per the Constitution, can it? Just clarity on that, and I'll hand over to Sweetie.
Yes. So, the constitutional requirements require it as that. But again, it would be a determination by consensus whether indeed this matter of public interest should be held in camera in accordance with Article 1468, and as also explained in the Frank Ajechum case. That is the locus classicus for this particular Article 146 matter. And so, for me, and just as it's done in court, the umpire, being the committee, they might reach out to all parties and say that, even though the Constitution says this matter should be held in camera, would you agree that it is held otherwise? And if all the parties agree to that consensus, then they have ceded to that kind of jurisdiction, and that would happen.
Right.
But if one party says no, then they will just go with the constitutional process. It happens all the time.
Christian Malam Hesse is a lawyer. Thank you for joining us this morning.
Malam Hesse, not Malam.
Malam Hesse.
You don't?
You're not a Malam.
Malam
Thank
Hesse.
you. And we also spoke to Andrew Sejapa Mercer. He's a lawyer, former MP for Second D and former tourism minister, as well as former deputy energy minister. And before we leave, are you looking for a home in a prime location? Then Nestor's Homes has got you covered. Our properties in Tema Community 26, just behind Palace Mall, after a serene atmosphere, easy access to transportation routes and social amenities. Those are the things you get access to. Off-plan price starts at $35,000 United States dollars. Give us a call. Let's discuss. 053-101-4440 or 053-101-4440. 4447. You can also visit our website at www.nestas.com.gh. Men will tell you about Syntex Tank.
Well, Ghana, let's talk water tanks. Do you know the secret to real water storage? It's simple. If your tank doesn't have the tortoise on it, then it's not the correct tank. That's right. The tortoise tank, Syntex Tank, is the champion of tanks. It is strong, durable, and built to handle our Ghanaian weather. So rain or shine, Syntex Tank has your back. It's got you covered. So my people, go outside, check your tank. If it doesn't have the achishidea, the tortoise on it, it's time to upgrade, scale up. Join the Syntex Tank family today and enjoy water storage that's tough, like a tortoise. Just call 0244 335 168 to buy now or find one of our 400 agents nationwide. You can also shop online at syntexgh.com. Syntex Tank, strong, tough. Do stick and stay. We'll be back with more action in a bit on the AM Show.